Section 22, Legal Hotline Q&A, Best Real Estate Practices, Arizona Market Introduction, from land and title to real-world legal questions. In Section 21, we discussed land elements, title, easements, ownership, probate, bankruptcy, and why agents must understand the legal rights connected to real property. Now we move into legal hotline questions that show how quickly real estate practice can overlap with fair housing, disability rights, HOA rules, commercial accessibility, and disclosure. This section is important because the right answer is not always obvious. Sometimes disclosure is required. Sometimes disclosure may create a fair housing violation. Sometimes an HOA rule looks valid on paper, but may still be unenforceable if it discriminates against a protected class. Group homes and disclosure. One legal hotline question asked whether a listing agent must disclose the presence of a home care facility for troubled teenagers in the neighborhood. The answer depends on the facts. Under the Federal Fair Housing Act, a person may not discriminate against someone with a disability in connection with the sale or rental of housing. If the residents are not considered disabled under the law, disclosure may be required. However, if the residents are protected as persons with disabilities, disclosure may be prohibited because it could create discriminatory treatment. Best practice: when group homes, disability, protected classes, or neighborhood concerns are involved, do not guess. Talk to the broker and recommend legal counsel. ADA accessibility in commercial property. Another legal hotline question involved a professional office building built in 1960. A tenant had an employee who used a wheelchair, but the bathroom door was too narrow. Under Title III of the Americans with Disabilities Act, places of public accommodation and commercial facilities must comply with accessibility requirements. Both the landlord and tenant may be responsible for compliance, even if the lease allocates responsibility between them. The lease may divide responsibility between landlord and tenant, but it does not eliminate liability to the disabled person. Best practice: commercial agents should be careful when accessibility issues arise and should recommend legal or ADA compliance guidance. Swimming pool barriers and seller responsibility. In another scenario, a buyer with small children wanted the seller to build a fence around the swimming pool. The seller refused. The seller is generally not required by fair housing laws to construct facilities for the protection of small children. Under the AAR residential resale real estate purchase contract, the buyer is typically responsible for costs related to complying with swimming pool barrier laws unless the parties agree otherwise. Best practice: if the buyer wants the seller to pay for pool barrier compliance, write it clearly into the offer. Drug and alcohol rehabilitation homes. A seller received an offer stating that the property would be used as a drug and alcohol rehabilitation home. The seller did not want to accept the offer because of that intended use. The legal hotline answer explained that a seller cannot refuse to sell based on disability protections if the home would be occupied by individuals protected under fair housing laws, such as persons recovering from drug addiction or alcoholism, excluding current illegal drug use. Best practice: never advise a seller to reject an offer based on protected class concerns. Age-restricted communities and disabled children. Age-restricted communities may be exempt from fair housing rules that prohibit discrimination against families with children. However, that exemption does not automatically allow discrimination against a person with a disability. In Kennedy v. Prescott Canyon Estates Homeowners Association, the Arizona Court of Appeals held that refusing to waive an age restriction to allow an underage disabled person to live with parents could violate reasonable accommodation requirements. Pets, disabilities, and CC&Rs. If CC&Rs prohibit pets, an individual with a disability may still be entitled to keep an animal if it is necessary for equal use and enjoyment of the home. However, if the animal is merely desired and not necessary as a reasonable accommodation, the no pet restriction may still be enforceable. Best practice: agents should avoid dismissing accommodation requests just because the HOA rules say no pets. HOA pool rules and children. An HOA rule prohibited anyone under 16 from using the community pool without an adult. A 13-year-old tenant was barred from the pool for violating the rule. The legal hotline explained that the Fair Housing Act generally prohibits discrimination against families with children, except in limited circumstances such as qualified senior housing. Rules that place unreasonable restrictions on children's access to community amenities may violate fair housing laws. Closing thought: best real estate practice means knowing when a question is bigger than the transaction. Fair housing, disability rights, ADA compliance, HOA rules, and disclosure decisions can create serious legal risk. If Section 21 taught us that land and title carry legal rights, Section 22 teaches us that people carry legal protections. A strong Arizona licensee must understand both. Online discussion question 1. Why should agents be careful when asked to disclose a group home in the neighborhood? Answer. Because disclosure may depend on whether the residents are protected under fair housing laws. If disability protections apply, disclosure could create a fair housing issue. Question 2. Why can both a commercial landlord and tenant be responsible for ADA accessibility? Answer. Because Title III may apply to places of public accommodation, and lease language allocating responsibility does not remove liability to the disabled person. Question 3. Why should agents be careful with HOA rules involving children or disability accommodations? Answer. Because HOA rules may be unenforceable if they create discrimination or fail to provide a reasonable accommodation required by fair housing laws.